Hey guys, and welcome to another episode of Dr. Divorce. Today I'm going to discuss the response to a restraining order, the hearing itself, what to expect, and also what you should do if you've been served with a restraining order. So you've been served with a restraining order. I know it must be a difficult time for you at the moment. I know it's very stressful and you're probably angry. You've looked over at the paperwork, you're confused, you're upset. There's a lot of things in there that are probably not true and you're worried. So first things first, calm down. The things that are in the DV100, which you should be looking at, you can look at the numeration on the form on the bottom or I believe the top, is look at what it's asking, look specifically what the allegations are. Also look at the temporary restraining order document itself. That should be attached to the request for restraining order. This temporary restraining order will include all the things that you're supposed to do or not do in this case so that you comply with the restraining order. You have to remember, this thing is temporary. It's not permanent. You're going to have your day in court. You're going to have an opportunity to set forth your position. You're going to be able to do that in DV120, which is the response to the request for the restraining order. In that document, you'll be able to write out exactly your position in defense to what the other person or the protected person is saying. In some cases, the restraining order is not granted. In some cases, the restraining order is denied. In any event, I would highly suggest you do not contact the person seeking protection if the restraining order was denied. Obviously, they're seeking protection for a reason. For whatever reason, the judge didn't grant them a restraining order, but that doesn't mean that the judge won't give them a restraining order at the hearing, or you won't give them additional facts for them to refile it again. The last thing you want to do is give them additional facts to refile the restraining order against you, and then you're having to deal with a second restraining order packet that was granted. You don't want that. If you were served with the restraining order and the temporary restraining order was granted, there's several things you need to consider. There's probably a stay away order, meaning that you can't contact and you can't be near this individual or the protected person. More than likely, it's your ex-girlfriend, it's a spouse or soon-to-be ex-spouse or a significant other whom you have a relationship with. There is typically, if there are children between you and the protected person, custody orders that are temporary in nature. Again, they're not orders for the rest of the duration of your children's lives, but for the most part, if the allegations in this case are severe enough, you may not have visitation for some time until the hearing, or there may be supervised visitations at an agency or through a family member if the judge granted that. So I know it's very difficult for some parents, some fathers or mothers who have been served with a restraining order that is temporary in nature, and along with that are custody and visitations orders that don't allow you to see your children. I know it's heartbreaking. I see people come to my office all the time, and unfortunately the only thing I can do and I can say to my clients is be patient. You will have your day in court. Another thing to consider if you've been served with a restraining order is, do you file a counter restraining order? This typically happens when you have a person on the other side who's narcissistic and is using a restraining order of their own as a tool to punish you or to antagonize you or to keep the relationship going in some sort of sick, twisted way. There are people who exist like this. They're the nastiest type of people. You don't want to joke around with people like this. If you have a basis to file a counter restraining order, please do so. Talk to an attorney, because you're definitely going to need the advice of an attorney to keep you emotionally stable and grounded during difficult times like that. And another consideration is that if you were arrested or if you're facing criminal charges have resulted in this protected person filing a restraining order against you, is whether you want to even open your mouth and say anything at the hearing. You have a Fifth Amendment right under the United States Constitution to remain silent. That applies to a restraining order hearing. So if you have a criminal case, for example, because you and your ex-partner got into an argument and things got a little heated, and for whatever reason, you ended up getting arrested and taken into custody by police, and this gave the protected person basis to go and file a restraining order against you. You don't want to go in unprepared. You should talk to an attorney to see whether it's your best option to assert your Fifth Amendment rights under the Constitution so that you can protect yourself. The last thing you want is to be in a position where what you said in the restraining order hearing be used against you in the criminal case, and then whatever defense you had at the criminal case is thrown out or goes by the wayside, especially if you have an attorney who is helping you with that, such as myself, since I do criminal defense. That does occur. I strongly advise clients who have both types of cases to assert their Fifth Amendment right. That does not mean that you automatically lose the restraining order case. Usually what happens, it's postponed, or the hearing is postponed to a later date to allow you time to protect your rights under the Fifth Amendment. Sorry about that. Someone called the phone and stopped the video. So going back now to the hearing itself. So you have your hearings. There may be multiple ones, like I said, depending on whether the person who filed the DV-100, which is the request for the restraining order, is requesting custody visitation orders or child support and alimony. So depending on those factors, you will have several hearings. Here in Stanislaus County anyways, you will. And other courts, I think, tend to do the same thing. But in any event, make sure that you calendar those hearings. Show up 30 minutes early because parking is difficult sometimes. The lines are long to get into court with the metal detectors. And you want to be able to sit there and be on time for roll call. Most judges will give you a small amount of time to present your case. They may allow a limited amount of evidence. Now, when I say evidence, most of you don't understand really what that means, other than what you may have heard on TV or CSI Miami or whatever it is. But in the world, in the legal world, evidence has a very special terminology and meaning, and the way to present that has its own set of procedures and rules. You could obviously try to Google it and see how it is that it works yourself, but I'll tell you that it can get very complicated very fast. So talk to an attorney about that. You're not going to have very much time, so you're going to be able to make your argument. If the judge believes that this case is going to take more than 15 minutes, the judge will set your case for what's called a trial or a long cause hearing that allows you to present your evidence. Now, this is for the restraining order portion. If you have child custody and visitation, be prepared to go into mediation. Stanislaus County, or all the courts, have mandatory mediation where you are required to go before a mediator who's a licensed family law therapist and who tries to have you guys reach a common ground regarding custody and visitation. Now, if there's a restraining order, don't fret, because once you have a visitation and custody order from that hearing, the judge will allow an exception that allows you and the other person to discuss the children only. Don't take it beyond that and think, well, I'm going to start bringing in the relationship while I'm discussing my issues with my kids. No, that's going to come back and bite you in the ass. Trust me, I see it happen all the time. If you have a hearing for financial issues, such as, again, child support or alimony, then you're going to have to come back typically on another day, and you'll have to bring in, again, your FL-150, which is your income and expense declaration, and the judge will look at your financials, the other person's financials to this FL-150, and then decide what it is that is a guideline for alimony and child support. I'm going to make a video that's completely separate on that, so don't be stressed if I don't talk about it thoroughly here. Again, I like to keep my videos short, 10 to 12 minutes, 15 at most. So I don't want to have you guys watch a video that's thoroughly long. And I hope that these videos help you in the sense that they give you some guidance and they're informative, and they allow you to take it to the next level if you can't afford an attorney. So I love doing these videos for you guys. It keeps me busy. If you have any other questions, please remember to call my office. You can do a telephone consult at 209-300-7825. Please follow me on Instagram and YouTube. You guys keep your head up and remember, rise up and succeed. I'm here for you. Have a great day.